Well, welcome everyone to the Highrise Diversity, Equity, and Inclusion vertical. For those of you I haven't met, my name is Laura Mercier, and I'll be facilitating our panel today. We have a really great group of panelists. I'm really excited about the topics. They're all kind of approaching DEI in the workplace from several unique angles, so I think it's going to be a really interesting topic for our members. Raja Marhaba is joining us. She will be talking about invisible or undiagnosed learning disabilities in the workplace. She'll address how employers can identify these and assist in making the employee a valuable addition to the organization. Welcome, Raja.
Thank you so much for having me.
Happy to have you here. Our next panelist will be employment attorney Christina Semmer, who will be speaking briefly about how diversity, equity, and inclusion laws have been enacted, both historically and currently. Welcome, Christina.
Thank you.
And finally, we have Residential Asset Management Vice President Alex Winborn, who will be talking about creating a compassionate work environment to build a productive team, among other things. Thanks for joining us, Alex. Welcome.
Yeah.
So just to let everyone know, as we have people signing on now, each panelist is going to speak today for about 10 minutes on their specific topic. And then we'll reserve time at the end of each for questions and comments. We'll reserve some time at the very end for discussion if we want to do that. So we'll just jump right in, and we're going to start with Raja today. Raja is the founder of a nonprofit organization, the Jonathan Foundation for Children with Learning Disabilities. Raja is the recipient of numerous awards, including the 2019 L'Oreal Paris Women of Worth Awards and the 2021 Diane Lipton Award for Outstanding Advocacy. In 2016, she received the Enterprising Women of the Year Award, and her company, Martech Construction, made the 2017 Inc. 5,000 fastest growing companies by industry and revenue list. Wow. Raja recently released her book entitled Unstoppable, a parent survival guide for special education services with an IEP or 504 plan. Very thrilled to have you here, Raja. Thanks for joining us.
A pleasure. Pleasure is all mine. First, I want to say you might question, what am I doing here speaking about corporations, employment, employees, when I'm a special education advocate for children? Well, my journey started over 25 years ago when I advocated for two of my sons, which are highly gifted and learning disabled. That means they have an IQ over 145, but one has severe dyslexia and one has reading and writing deficits and deals with depression. As I went through the school system, I ended up suing the second largest school district in the nation and prevailed, but it came at a heavy cost to my family. And when I went through that journey, I realized it's a national broken special education system. There's not really a lot of help for these children. And if you don't have a parent that's knowledgeable or has the know-how on what to do and advocate for their children, it becomes a problem. And when I went through my journey, I was running my construction company simultaneously, and I decided to create a nonprofit for special education, specifically because of my journey. And as I was working in my construction company, and I would interview staff and I would interview field electricians that would come to me, I realized that a lot of them had some sort of learning disability. And the only reason I understood it is because of my journey in special education. And I had employees that worked for me that had auditory processing deficits, that had dyslexia. I had employees that could not follow 2 or 3 instructions at one time, and you had to accommodate them and give them one instruction at a time. As an employer, it may not be the most financially reasonable way or feasible way to make money, because employees cost you money because you're paying them to do a task. At the same time, I went through such a journey with my family that I could understand and see if an employee of mine had some sort of learning disability, and I call it the invisible disability, because you cannot see it in the exterior of the person, and you don't know what the struggles interior, what happens within the confinements of the brain and what's going on. And as this progressed in my construction company, I was able to, there has to be a trust built between the employer and employee so that the employee feels comfortable to tell you what the deficits are. And if they don't, as an employer, if I was not an educated employer, then I would probably write that employee off, give them 3 warnings and fire that employee. But I realized as I was going through the process as an employer for a construction company, that I could do a little bit more to help them because I understood the deficits. And so an employee that had dyslexia, we would give them software programs, help them to take notes, give them a recording. They could record meetings to help them understand it, because a lot of them were auditory learners. They learned hearing versus reading and writing. And of course, we'd get permission from the various people in the meetings to get the recordings so that the employee can actually access the work and become a benefit and an asset to us versus the opposite. We have employees in the field as electricians that did not process very well. And if we gave them 1 or 2 instructions, they'll do one and not do the rest of it. And then we realized we could fire them also, right? You do the 3 warnings, you try to work with them, you try to help them, and they're still not getting it. And when we accommodated their deficits and helped them learn different ways to change the tasks, that it's easier for them and they're not embarrassed to come to us and tell us, how can we help them make their job easier for them, at the same time continue to be an asset for us. A lot of these individuals have ADHD and high functioning autism, and they are the most valuable employees an employer may have, because they come up with a different type of characteristics that a typical person doesn't have. And those employees I would put on the top of my balance sheet, in the asset portion of my balance sheet. And I just wanted to be part of this to help employers understand the hidden invisible disability that's happening with our employees. And I guarantee you, each of you, that as adults, you might have that and not know it and not be identified as that. You might have family members that have this. I have friends that are adults that have never been diagnosed, and yet I have a gentleman friend that emails his wife all his emails prior to sending them out, so she can review the grammar and the spelling, so he doesn't get fired, because he's too embarrassed, and he's at my age, middle life, and it's just really difficult and puts a lot of stress on the adults that have not been identified. But I wanted to bring awareness to the group so that in your employment areas that you might be just take a step back and think about it and try to implement something to help them access their tasks so that they can do a better job for you.
Raja, how do you identify if an individual may have a learning disability?
Well, a lot of them, believe it or not, look at their handwritings. Sometimes the penmanship is not the best, especially for individuals that have dyslexia, the spelling, the grammar. Before you write them off, maybe question. If you're comfortable enough, HR might need to get involved, and our attorney on the panel might have some suggestions on what to do, because it's a very gray area. But it's just looking at them. Instead of judging them that, oh, this person is non-teachable, maybe this person is teachable. I usually see the first sign for me is their handwriting. When I see their handwriting, and then I pay attention to their grammar, and I pay attention to certain processes. If I give them tasks in my office or in the field, if they get to have tasks given to them by our project manager and superintendent, and then they would come back and tell me, this person is just not getting it. I told him 3 times to go and do this task, and he doesn't do it. I don't want to do it. And then I don't want to deal with him. And so then I say, talk to the employee, see, what's going on with him. A lot of these employees are afraid to say that I'm dyslexic, or afraid to say that I have auditory processing deficits, afraid to say that I have autism, I'm neurodivergent now. Maybe now, because they're changing the conversation, they could say I'm neurodivergent. And when they say I'm neurodivergent, then something is going on, and you might need to dig a little deeper within the guidelines of employment.
What are reasonable accommodations for an employee with a suspected disability? What kind of things would we be looking at?
Well, if they're dyslexic and they have high comprehension, most ADHD individuals have high comprehension. Not all of them, the spectrum is really huge, but the majority do. They process very fast, they talk very fast, they understand things faster than their peers. I'll give you an example. My son Jonathan has a higher comprehension than me, and I'm his mother, and I take him to meetings with me because he gets things I don't get. So when I was in the construction world and he was a superintendent for our projects, I would attend meetings with him and then we'd debrief after the meetings and I'd say, what did you get that I didn't get? Or I'll tell him what I understood and then he'll tell me what he understood. So they're very valuable. So accommodations would be implementing a software program or text-to-speech program. They have WINS or Kurzweil software programs that can be implemented to help them better read and write and correspond. It has a spelling check, grammar check. Then the spell checks have phonemic words embedded into them. So if they're dyslexic, they listen and hear things in a phonemic way. They spell things phonetically. They're not going to spell things the right way. And that's why a lot of people in administration end up having to proof and reproof and reread because they're doing these mistakes without realizing it's the subconscious. It's just the way their brain is wired in the field. If you have employees that have a processing problem, auditory processing problem, and you see that because they're not doing the task the way you want them to do, have a talk with them and come up with ways. Would it be easier if I told you to do this task and when you're done with it, come back, or have some supervisor in the field to talk to them that understands it, that there's an open communication and the employee feels comfortable. The employee also has to come to the employer and feel comfortable enough to say, hey, I'm dyslexic, I need help. I don't process. I had an employee that had traumatic brain injury, and for the most time in the field, my son would tell me, Mom, I can't train this man, and he was in his 40s. I can't train him. I don't know what it is. And he tried to tell him, go do this task and come back to me. I know it takes a lot of strain in the employment environment, but we have to come up with different ways that are strategic that could be feasible for both. In the end, this gentleman came to my son and said, I have traumatic brain injury, and the reason that I cannot do all these tasks is because I can't. And we were forced to let him go, not because we wanted to. I felt horrible about it, but because it got to a point where I could not sustain the cost. We pay electricians $95 an hour. He was getting $95 an hour, and he could not perform the task the way a journeyman electrician needed to perform a task. And so at that point in time, it was a tough call. It's a hard decision to make.
And so that kind of leads to another question that I was just thinking about, and maybe for our next panelists as well, as what do you do if you've exhausted all remedies to accommodate an employee and they're still not performing?
Were you throwing that one to me, Laura?
I think that was still for Raja.
Okay.
Christina will be up next.
That one's for me. I think HR needs to get involved, and I think Christina made a point of that when we first had our pre-briefing, our meeting about this panel. And it's really important to get HR involved. And I don't know, Christina, maybe you can chime in about what the rules are, because it's confidentiality and discrimination. It's a great area, but it's a really important area because I believe we are all affected by this. Even though I'm in the nonprofit world, I'm still affected by this. It's not going to go away. And once the employees that I dealt with in my company, I made them feel really comfortable. And when I saw something and I saw them struggling, I would go to them and say, you're having problems with this, this, and that, these different tasks. And they'll say, yeah. And they go, well, I'm in special education and this is what I do. And this is what I see. And you okay with it? And then they open up. I can do that. I have the expert background. Typical employers can't do that because they don't have my background. I see things that the typical employer does not see. And maybe there needs to be training for employers to better understand and have awareness on how to figure this out, and have their HR department have a training in special education and what to look for.
Sure.
From the legal perspective on that, there is a duty to provide reasonable accommodation, but that is really only triggered, or even those conversations around, and it's called the interactive process, that really is only triggered when an individual has a visible disability. So think, maybe someone with a prosthetic leg, and to get to their, desk, they need to take stairs. Okay, can you reasonably accommodate that person? Is there an elevator? Is there some other, relocate their office to the lower floor? For indivisible, I keep saying indivisible, invisible disabilities, it's obviously trickier because as an employer or a manager, you don't want to go up to an employee and say, hey, you seem to be struggling. Do you have an auditory processing disorder or are you dyslexic? Employers do not want to know, they don't need to know the diagnosis. They just need to know if the employee has restrictions. And then based on those restrictions, can you reach an accommodation? So if an employer cannot visually see that there's a disability, it really does put the onus on the employee to bring it to the employer's attention. I'm struggling with X. Can you help me? At which point the employer should say, have your doctor complete a form that identifies your restrictions. For example, need to be able to tape record if possible, or can employee needs to be able to read instructions in writing. And so maybe the reasonable accommodation there is the employee is provided an agenda before a meeting. That doesn't necessarily mean that the employer has to create an agenda, because then it becomes a question of whether it's an undue burden, but it's an interactive process because it's supposed to be an open communication between the employee and the employer. But again, the employer would not ask what the disability is. The employee can offer that, but the employer is not going to ask.
Thank you, Christina.
I got a real quick question, Christina, on that. So let's say as an employer, you suspect that somebody has, a difference in learning and processing. I mean, I guess whenever I hear the term disability, it's just anything outside the norm. So probably, if Elon Musk came to work for me when he was 20, I would think, oh my God, I can't hire this guy. And you'd miss out on all the, great opportunities. Is it allowable if an employee comes to you and says they are having some kind of learning disability? Is it allowable to start with taking an IQ test, or where do you start the conversation?
I wouldn't do an IQ test. I would say, talk to your doctor about what your limitations are. And oftentimes the employer will take the job description, give it to the employee so the employee can then take it to their doctor. And so the doctor can see, what is the employee supposed to be doing in their job? The employee still has to be able to provide do the essential functions of their job, even with an accommodation. So that gets to Raja's point about that employee with the traumatic brain injury. He could not perform the essential functions even with an accommodation. So that person, it's okay to terminate them. Sensitive, but legally fine. In that situation, you wouldn't want to be putting yourself as the employer in the position of the doctor and requiring testing of any kind. I think at that point you would say, talk to your doctor, and if you need to get testing, please let us know, what the restrictions are based on that testing. Come back to us. We're happy to engage and happy to discuss with you. If you'd like to bring your doctor in and you provide authorization for us to have that conversation, fine. But it does get very sensitive, and employers should not pry too deeply on the actual underlying condition.
Got it. Thank you.
Other questions before we move on? We'll have time at the end to kind of go through some of these. Okay, well, we just heard Christina talking. She's an employment attorney, an experienced employment lawyer and advisor with GBG LLP, a certified women-owned law firm based in San Francisco and Los Angeles. Christina's employment law practice includes representing employers with respect to various disputes, including claims of wrongful termination, discrimination, retaliation, harassment, and wage and hour violations. Christina also provides advice and counsel as well as guidance to her clients to assist them with avoiding and mitigating litigation and liability risks. Christina also has 4 siblings, and her parents are 2 retired lawyers, so she has a lifetime of personal experience with problem solving and negotiating compromises. She uses these skills to ensure her clients are comfortable as possible with the litigation process and confident they have a true advocate. Welcome, Christina. Thank you for joining us.
Thank you very much. And before I kind of give my spiel, I would just reiterate that disability accommodation is one of the thorniest issues in employment law. It is, you know, far and away in terms of the actual lawsuits where I defend the employer. Disability discrimination cases and failure to accommodate are greater than 50% of the type of work that I do over, you know, race or gender or anything else, disability far and away, because there's so many nuances. And I do think that, and I've mentioned this to Laura and Raja too, maybe there will be a further opportunity to explore if folks within Highrise are interested, kind of what that means, the reasonable accommodations and how to kind of, can't say liability proof, but, you know, make your operations better. So that will be a topic for another day, perhaps. So today I wanted to speak a bit about just DEI laws. And I think many of us, when we hear the phrase DEI, diversity, equity, and inclusion, we think that it's a new phrase, but it's a new phrase for at least a legal concept that has been around for the last 60 years. And probably a number of you, since you've opted into participating in this panel, are more attuned to the idea of DEI, but you know that other people, it's just kind of newly on their radar, maybe through workplace training, like their mandatory anti-harassment training or anti-discrimination training, or through workplace initiatives. A lot of workplaces have affinity groups. Like, you know, there's a Black Lawyers Association or a Women Lawyers Association, even within companies. So I think the concept is on the radar for folks, but again, these historical protections have been around for a long time. And so I just wanted to speak briefly about kind of the 4 of the biggest and perhaps most well-known historical laws that relate to what I'll call the OG DEI laws, the original DEI laws, and then give a brief summary about what are kind of the newer laws that really get at the DEI concept. And this is, I don't know where everyone is located. I'm in California. I would say California provides more protections than probably any other state for employees. And so some of my examples will be California, but I will try to give some examples or at least a sense of where some of these newer laws are cropping up. But it is useful to point out that if you hear of laws being passed in California or New York, for example, that affect diversity, equity, and inclusion in the workplace, that's kind of a sign of where things might end up in the future. Maybe it's going to take 5 to 10 years, but California and New York are pretty good bellwethers of what's to come. So just very briefly, I would say the big 4 DEI laws would be, you know, the first one that came out was the Equal Pay Act of 1963, and that was signed by President Kennedy. And it's just about to celebrate the 60th anniversary. And that's the common one we know. It requires employers to pay men and women equal pay for equal work. And so, you know, equal pay for equal work is a phrase that many of us are familiar with. And then, of course, there's the Title VII of the Civil Rights Act of 1964. And that bans employers from discriminating against either job applicants or employees on the basis of, and there's several what you call protected characteristics: race, color, religion, sex, or national origin. So you notice age is not in there. Sex, since the enactment of Title VII, sex has been expanded to include pregnancy and transgender status and sexual orientation. And Title VII also requires employers to reasonably accommodate religious practices unless it causes undue hardship. I wouldn't say that that's necessarily a hot button issue as much as disability discrimination, but it's kind of the same framework regarding reasonable accommodation. So for example, if an employee needs the Sabbath off every week, is that a reasonable accommodation for that employer? So that's Title VII. And then there's the Age Discrimination in Employment Act, the ADEA. and that prohibits discrimination against people who are 40 years and older. There definitely is some talk in more recent years of 40 years. Is that really, old enough to need protection? I just turned 40 this year, and I was asked to say a few words at my little family party, and I said, yay, I can sue for age discrimination if I need to. So 40 is quite young, and but we do see age discrimination cases still. And then Raja kind of touched on this a bit, but the Americans with Disabilities Act, that's more recent, that's 1990, and it prohibits discrimination against people with disabilities, people who are regarded as having a disability, or people who have a relationship or an association with someone with a disability. So maybe your child has a disability, the employer can't take any negative adverse action against you because of that. And so the ADA extends to both physical or emotional impairment, but under the federal law, that has to, a disability is something that substantially limits one or more basic life activities. So that's different than California and some other states that have a broader definition of disability, that it doesn't have to substantially limit a major life function, but only has to limit a major life function. And so in that instance, the federal ADA kind of sets the floor rather than the ceiling of who might be protected against disability discrimination. So that's something to keep in mind for folks depending on what state you're living in. And so, the purpose of these laws dating back 60 years is, of course, to ensure that women, minorities, people with disabilities have an equal ability to participate in an important life function for all of us, which is gainful employment, being independent, being able to go to work and feeling like you can contribute. And so a big piece of that, of course, is being paid the same. There are other things that are important, but some of the more recent DEI laws really get at pay equity. And so we'll talk about that a bit. So again, this is kind of just a little sampler. Each of these kind of areas of new law could be and are their own presentation and among themselves. So I'm just going to highlight some that are kind of, they're not one-offs. It's not just happening in one state or two states. It's more of a trend now. And if it's not in your state now, it may in the future, depending on the politics of your state, essentially. But so one thing that and a lot of these actually, I should say, relate to equal pay and ensuring equal pay. So the first kind of type of law that I'm going to cover is laws that prohibit prospective employers from asking job applicants about salary history. And the purpose behind this type of law is to combat structural barriers for women and minorities. And I think that would equally apply to individuals with disabilities. So if historically marginalized people are held back and held down by their past salary, if you make a lower amount because maybe there's been discrimination in your past, or maybe you've worked in a historically female-dominated industry where your wages don't reflect your value, or we're just valuing that type of work less. If you have to tell your incoming potential new employer what you're making, then they might keep giving you lower pay. And then at the end of your career, you're really, really behind where a non-diverse employee might be. So about 21 states have some sort of pay history, a ban on pay history questions. And again, there are various kind of iterations of this. And for example, most of these states will ban employers from asking about salary history on job applications or in interviews. But whether or not the employer can use that information against you, essentially, if you voluntarily disclose it, that differs kind of from state to state. And whether or not this prohibition extends to applicants and current employees, because if you want to apply for a job within the same company or in, you know, a subsidiary or something, whether or not you can, employers are banned from that depends on the state. So the next kind of series of laws that I would mention, and a lot of these again get at pay equity, is laws that require employers to disclose their salary range in job postings. And this one, if you're in California, this has recently been enacted, and this is kind of a newer type of law. There are 7 states plus a handful of cities and counties, and New York City is a big one, that have some sort of pay transparency law. And so again, the specifics of those vary, but more or less it requires an employer to provide a salary range to job applicants. And again, that's so applicants can decide whether they think that employer is going to compensate them fairly, equitably. And again, the variations kind of include, some states you have to only provide the salary history if an applicant requests it. Some states only have to provide the salary history after an individual makes it through a certain round of the interview process. So perhaps after the employer has offered the job. Because then let's say you're offered $50,000 and you're a Black woman, and you're wondering, hey, I wonder what my white male counterparts are making. You could ask for the salary history, and it's not going to say, you know, white men are paid this, but it'll at least require a range. And then you can decide, hey, if I'm at the lowest end of the range, maybe I ask, is there a reason that I am at the lower end of this range? So that's, again, the transparency is intended to foster equity and equal pay. Another kind of new movement, well, actually this one has been around for a longer period of time, but laws that protect employees who disclose or discuss their pay with their colleagues. And so actually the National Labor Relations Act was passed in 1935, and it more or less says that employers can't prohibit employees from discussing like the terms and conditions of their employment, but there's so many carve-outs from that. For example, doesn't apply to supervisors, doesn't apply to government employees. So historically, there's supposed to be an ability of employees to share salary information, but in practice, that really has not carried out, and probably a lot of us just are sensitive to discussing that amongst our colleagues. Our employers maybe discourage that implicitly or explicitly. There is some generational stuff going on where Gen Z and younger generations are more open. Studies have shown about talking about what they make, and you know, employers probably don't want that, but it's great for employees, because if you know that your colleague is making more than you might start advocating for yourself to get that pay raise, or questioning why it is that you're not making what they're making. So there's not as much on the interweb as I would say about this, but it looks like about half of the states in the country have some type of ban on employers being able to tell employees you cannot discuss pay with your colleagues. How am I on time, Laura?
I think we're doing okay. We've got a few more minutes, and then we'll take some questions and move on to Alex. Thanks, Christina.
Perfect. A couple more. If you've heard of ban the box laws or fair chance laws, these types of laws limit an employer's ability to ask job applicants about criminal history. And of course, you know, many of us in the past have completed a job application, and there's that little box that says, have you ever been convicted of a felony? And, you know, check yes or check no. And for a lot of individuals who have a criminal past, the mere fact of checking that box, your application is just going to be thrown away immediately, not further considered. And so the purpose of these ban the box laws isn't to make employers hire everyone who has a criminal background. That would probably be extreme. But the laws are really intended to encourage employers to give folks who have a criminal history a chance. So in a lot of these states, you can only maybe ask about a felony history or criminal history after you've made a conditional offer of employment, because at that point, you've really given that person a chance to express their qualifications, their experience, and how they might be a good fit for the job. And if they do disclose a criminal history, some states handle that differently. There's usually, a prospective employee needs to be asked to kind of explain the background so the employer can make a kind of informed decision about whether or not that might affect their job. Of course, there are carve-outs. Most of these laws only apply to employers of a certain size. For example, in Arizona, it has to be for employers that have more than 15 employees. Some of these states, this law only applies to public sector employers, not private sector employers. And so I was able to figure out that it looks like a total of 35 states plus the District of Columbia have adopted a ban the box law of some kind. It's only 13 of those have extended it to private employers. So I think, again, it's just to take a holistic view of the job applicant and maybe not hold criminal history against people, in part recognizing that criminal histories have a lot of systemic racial prejudices built into them. Lastly, and just briefly mention what are called Crown laws. And this is the federal version of this is creating a respectful and open world for natural hair. This passed in the US House in March 2022, but it has not been enacted at the federal level. And there's only a couple states that have passed this. Again, the ones that are more progressive in their laws protecting employees, but it's been passed in California, New York, New Jersey, and Virginia. And these laws prohibit employment discrimination against based on hairstyles, essentially. So hairstyles typically associated with the Black community, like braids or twists or locks or textured hair. So California, again, you're explicitly, that is another grounds for discrimination, separate and apart from race discrimination. So, there are others, but I think those are kind of the ones that I wanted to cover because I thought that there was a chance that it might apply to maybe most or some of you on this Zoom. But if you have any questions, please let me know. And thanks for listening.
I have a question.
Yeah.
What do employers do when the employees start talking to each other about how much they're making and the benefits and the bonuses? I've had issues like that in my construction company and it caused me havoc. So what are the employers' rights?
Well, you can't, and again, depending on what state you're in, but assuming we're in California, which is where I advise employers, you can't really tamp that down. You can ask them not to do it during work time. You can tell people that if they have questions or concerns about their compensation to come speak with you. But you're right. I mean, if you have an employee who learns that they think that they're doing equal work and they're getting paid less, they will likely have questions. And so employers really, when they're setting pay, should actively think about what are the reasons that I'm giving this person a higher salary. And if there's a legitimate reason, their educational credentials, their years of experience, the actual responsibilities that they perform, those are, quote, bona fide reasons to have a pay differential. So what you want is not to be making arbitrary decisions around that. And what's interesting is under the federal law, like I said, there's that phrase equal pay for equal work. In California, and perhaps some other states, it's equal pay for substantially similar work. And so some employers have gotten around it by maybe they give someone a slightly different title. there's going to be an analysis of what is the work that the individual is performing, and is it substantially similar. I had a case where it was a Black woman, and she learned that two of her colleagues, or male colleagues, were paid more than her. One of them was actually biracial, but she said that he was white presenting, and the other male was white. And she learned that they were paid more than her. They were working on a specific computer programming function that she wasn't, but to her mind, there was a question about whether she was performing substantially similar work. And so you need to be able to have that justification, a legitimate business reason that has nothing to do with, a protected characteristic like race or gender or religion or disability status, et cetera. But I agree, it's not easy for employers to comply with the law. And there's a lot of job security for me in California because these issues come up a lot. But I think that Alex's, when he talks about empathy, I think a lot of it is about just having open communication and being able to explain calmly to, and without being defensive to your employees anytime they bring you a concern, rather than automatically assuming that they're, ungrateful or X, Y, or Z. Sorry, Raja, no easy answer.
Well,
So,
thank you, Christina. I'm going to jump right into Alex, and then we'll have a few minutes at the end for questions. That was great information. Thank you so much. So next we have Alex Winborn joining us. He's a dynamic and accomplished leader serving as the Vice President of Residential Asset Management at H.G. Fenton and Company. With diverse leadership background and extensive experience in residential property management and multiple other industries, Alex brings a unique blend of competencies and expertise to his position. Beyond his role as a leader, Alex is also an accomplished writer. He has authored and published numerous articles. I'm really excited to have him here today. Welcome, Alex.
Wow, that was a really long intro. Thank you to everyone that had to go through that. Raja, one last point I would back to your question really quick, and Christina and Raja, thank you so much. It was so informational, the stuff you guys are providing. Is, it depends also what your comp philosophy is and what you anchor into. So if you anchor into skill set and competency, you may have some discrepancies. And sometimes I found that if you have a strong enough anchor of your comp philosophy, that tends to help have those conversations. But as we go through what I want to talk about, it's really more of the human-centric side of this. You can have laws, you can have different things that you got to kind of pick up on, but how do you even get to a place where you're able to pick up on some of the things that you're seeing? And that's where, when people ask me what's the one thing they can do to improve DEI at their company, it's their ability to have empathy. And if you can take anything away from today, for me, it's 3 really quick bullet points. Can you always ask one more question, no matter what the situation is? Okay, can you seek to understand? If you think you heard someone speak and you think you know exactly and how to understand what they said, no one's that good. Ask another question. Really be engaged and get the information you need to make the best decision possible. And here's another one where I think people don't give themselves a lot of permission. Is if you make a decision or you're going to get close to making a decision around some elements of DEI, and there's some element of a change in the circumstances of information that's kind of evolved, give yourself permission to change what you think you should do. I always tend to hear stories of, I knew I was going to do this from the moment I heard about this situation. And it's like, well, that doesn't really support the person as a human being, right? We say life happens, but then we got to remember people join us for work and they've had this whole story before they even joined us. In certain cases, 20, 30 plus years of a story. And that's what they bring with them. They bring a very unique, diverse story. So people always say, well, where do I even start with DEI? Start with where you're currently at. Do you know where your diversity is? And is your environment very inclusive? When you have, I see a lot of lawsuits in different places I've been, and sometimes I question whether or not our environment is very inclusive. If it is, you tend to have less of that as a matter of how you operate. You know, one of the things I like to ask people here is, are you being seen? Right, there's a lot of questions on how you're doing, and you could do great, but based on what you're doing, you may not be seen. I give you an example. I went to the restaurant the other day, and as soon as I walk in, the person asked me if I was there for DoorDash. And I was there for a meal, to sit down and eat a meal. But that was the first thing that was said to me. And it's never a knock on whatever they said I probably do. It's just a matter of, well, that's not what I'm there for. And I wish that person would have just asked one more question. And maybe not that question in certain ways, right? So there's a level of empathy that goes with that, and you have more inclusive environments. And sometimes when I get that in a restaurant, I can almost guarantee that environment is not really inclusive. You know, our kind of what I call unconscious bias come out in different ways, me included, right, at times. And our ability to be able to anchor in, seeking to understand. We recently did some DEI focus groups, and we learned a lot. We learned that, you know, while we may think people are being seen, they're not in certain cases. And we do a great job of coming up with action plans to kind of really understand what that can look like. But it all starts with asking the question, which most people are almost somewhat fearful of. And then I think in a way why most people don't like talking about it, because they don't get asked about it. And you think about something that you don't get asked about a lot, and then all of a sudden someone wants you to talk about it. You're like, I don't know how that makes me feel good. Or so us as leaders, the more we can anchor in on our training of having empathy and our ability to truly understand that people have diverse backgrounds, they come with different stories, and you can meet them where they are. You can try to understand their story and be proactive in meeting them where they are. You will get a lot more out of your employees. You'll get an employee base that feels like they're a part of something, that they have a sense of belonging, and that ultimately they're being seen. Everyone focuses a lot on, how do I attract more DEI candidates? And I would say, well, start with the ones you have. How are they feeling? Because they're the ones that are the promoter for you on how things are going, and they're out in the workforce with others that are with them, and that's what brings in that diversity. Going out and trying to seek and how you're going to have balance in the diversity, it's pretty challenging for many reasons, right? Some of it more societal than anything in certain cases, but it's a really challenging thing to do. But if there's a level of care, you know, everyone gets upset sometimes with Glassdoor and what they offer. And Glassdoor is a great tool for people to understand how do you show up and have an inclusive environment. So I just wanted to leave you with that human-centric approach, where just one more question. That person might have just had a story that you just didn't quite know they had that story, and that changes the circumstances of how you view that situation, and you can, you know, find a way to make more of an objective decision making. Those are the kind of things that empathy can bring into the equation, and Christina will probably enjoy this. You'll see less lawsuits, or you won't be as concerned about, I didn't follow this law, or I didn't follow that law. Just, did you follow the law of, is this person human, and have I truly connected with them? Do they feel like they're being seen? If we can do that, and again, I get it, it's challenging because you have layers of leadership that at certain times it's playing the telephone game, and the message gets different each time. But, you know, a message of, you're seen here, everyone can gravitate towards that message, and everyone can kind of find a way to link to it if we as leaders care enough about their story and how, you know, from when they show up. But that was what I had today. Those are the three things. Ask one more question when in doubt. Seek to understand kind of the circumstances which are around a situation. And then ultimately, if the circumstances have changed, give yourself permission to take a different approach.
Great
Alex,
message, Alex. Thank you. Yeah, please go ahead, Christina.
Yeah, I was thinking about your kind of those 3 points and tying it to Raja's experience again with the employee with the traumatic brain injury, because Raja's efforts to seek to understand what was going on with this individual, if there is a way to accommodate that person, that process at least probably made the employee feel heard. And in the end, although that person could not be accommodated in a way that they could keep their job, I'm guessing, and Raja, you don't have to say anything, that individual probably did not sue Raja's company because they felt like at least the company made a hard decision, was not making a decision lightly, and really tried to work with them, because you're right that reduces lawsuits. Of course, it's also what you want to do as the right thing, but it does help with liability, because employment lawsuits in particular, the legal aspect is only one part of it. The personal and emotional aspect is so important in my area of law, because people's jobs are so central to their identity. And if they feel like they've been treated like a human being, like their management has been supportive of, them, if they felt like they were having challenges due to, their race or their gender or their disability, they're less likely to sue, because they are less likely to immediately think, man, my employer screwed me. So.
No, I agree with you. I was not sued. We put a lot of programs and accommodations in place for this particular employee, but he was an electrician. He had to climb the ladder up and down. He would get dizzy sometimes. He would forget things. It just got to the point where he knew himself he could not function and do the job the way the description was. And when we met originally, and he came to us and told us he had traumatic brain injury, and that he knew it. He felt really bad. We felt horrible because we really tried to work with this employee, but it was beyond us at that point.
And I think employees do have a sense of whether their employer is genuinely trying to work with them, or just trying to check the box of, I've worked with them so I can performance manage them out. And a big part of that is the empathy that Alex talks about.
Yeah, I agree with that. This has to be a communication, constant open communication, and a comfort zone on the employee side and on the employer side.
Yep. And I think for those of you who manage employees, it's important to make sure that your HR person, employee, or if you are large enough to have a company that has a disability management specialist in particular, that those individuals aren't getting so burnt out in their job that they're losing that ability to empathize, or that might be a little bit of a strong word that I'm comfortable with from like the legal perspective, but really that the individual who is responsible for having those important conversations with employees doesn't feel so burnt out that they're losing their ability to engage with that person. And I do see that sometimes.
Kristen, you had a question? She's unmuting.
There we go. Thanks so much for this panel. This has been great. I was just wondering what the responsibility of the employer is in a situation where a disability is undisclosed.
Yeah, there really isn't one. If the disability is, usually what happens though, frankly, is, and Raja's probably seen this quite a bit, is the employee gets written up and then they disclose that something is going on. And maybe that has contributed to the reason that they're being written up. At that point, the employer should engage with them, have that interactive process, figure out whether reasonable accommodations can be made. Of course, it's a case-by-case basis, but that's usually a good time to either loop in your HR or your employment attorney. Oftentimes that will mean maybe you put that PIP, or that CAP, corrective action plan, on hold to see if implementing accommodations, reasonable accommodations, will help that employee get on track. What you don't usually want to do is an employee discloses a disability and then you immediately take some type of action against them, because that will look retaliatory. But again, if it's an invisible disability, you don't have an obligation to say, hey, you're struggling here. Are you disabled? Do you have a medical condition that's causing this? And the better approach is, you seem to be struggling with X, Y, or Z. Is there something going on that is making this challenging for you? So you're giving them space and an opportunity to share with you. But if they don't, there's nothing you can do, and you don't want to violate their privacy.
That's true. Most of my office employees, when they got stuck on a task, they would speak out loud and say, I can't do this. I don't know how to do this. They usually get frustrated because of their limitations and then they start opening up. But I have to stress there has to be extreme comfort between employer-employee relationship, or that employee is not going to open up.
And the reality is, most companies, if they're larger, are just simply not going to have the amount of time and resources to put this much into an individual employee, especially when you have, the manager is involved and HR is involved. But it is at least good to go into it with a mind frame of understanding, asking the questions and seeing what they're willing to share, and not going into something thinking, man, this person sucks as an employee. It's better to think, man, they are having a hard time with this. I wonder if there's something we can do to help them. Even if ultimately at the end of the day, they can't do it and you have to terminate them, they will feel better about the process, and that is less likely that they will sue you.
Thank you all. We have about 1 minute left. Any questions, comments? Well, thank you for this wealth of information from our panelists. This was just an exceptional presentation today. And thank you to the members for showing up for our Highrise Diversity, Equity, and Inclusion vertical. Hope to see you all soon. Have a great day.